On the record in the matter 25 CM 202, State of Wisconsin versus Trent Sutherland. The state appears through Assistant District Attorney Jose Vila in person. Mr. Sutherland appears in person with counsel Amber Sherwood. We're set here today in this matter for a status conference. Please update the court.
Yes, Your Honor. So we have an offer on the table. If Mr. Sutherland does AODA and follow through, it would be 15 days in the county jail. As you heard off the record, Mr. Sutherland had a job interview yesterday.
All right, pause right here, because this is one of those cases where the courtroom feels like a crossroads. You've got a retail theft allegation, a job interview, and a judge who clearly knows this defendant's history. The big question is, does this turn into a comeback story, or a fast slide back into the system? And watch how the court frames jail versus treatment, because that's where the real twist lives.
The offer only involved probation.
It's an either or, Your Honor. The offer was for probation, or if he didn't want to do probation and in lieu of probation, he could do the 15 days jail. That's choice is his.
Oh, in lieu of probation, 15 days jail.
Correct.
All right. Sorry, I didn't mean to interrupt, but I'm like, I thought it was a probationary offer.
Okay. And we are wishing to take that offer at this time. We were asking for one more status just so that Mr. Sutherland can get his funds to get his AODA assessment and follow through started with Aurora before he ends up incarcerated for the 15 days.
This is a key legal and life moment. The court's basically dealing with a negotiation fork, probation with AODA alcohol and other drug abuse assessment versus 15 days in jail. And notice the judge acknowledging return property without deciding guilt, because this is still framed as an allegation. The judge is signaling, I'm open to alternatives, but I'm not ignoring the pattern. Viewers, if you were the judge, are you pushing treatment or pushing jail?
I know Mr. Sutherland quite well.
Mm-hmm.
I know his background. I know all of those things. Excuse me. I understand that this is a retail theft allegation, and it's my understanding that if anything was allegedly taken, it was returned.
That's correct.
I know what Mr. Sutherland is trying to accomplish with his life. This is something that I wouldn't be opposed if you want to argue for electronic monitor.
Okay.
So, and we have different monitors now, Mr. Sutherland. They're monitors that are like scram bracelets, but they're called buddies, and you can't take them off. You can't remove them. They're GPS and they're alcohol testing 24/7. So, they do cost,
I believe it was $20 a day.
I think it's 25 a day.
It was 25.
25 a day.
This judge is doing something you don't always see, openly addressing the risk of jail as a crime school for low-risk defendants. And the alternative isn't free pass, it's tight supervision, GPS plus 24/7 alcohol testing, and it costs real money per day. That's the hidden pressure point. If you're broke, choose the monitor can feel impossible. So tell me, does paying for accountability make sense? Or does it punish poverty?
Well, or if you want to sit the 15 days. But you and I both know, maybe Miss Sherwood does, maybe she doesn't. She's getting her roots into her job, that sometimes when you put low risk offenders in jail with other higher risk offenders, it kind of leads them down the wrong path again. And Mr. Sutherland, you may have been there at one time. You're not there right now. I don't know the ins and outs. I don't get discovery of what happened here in this case and what you were thinking. But you'll get to tell me, and you know me, then I'll probably be hard on you a little bit and figure out why. But so that is where the court stands. So if you want to talk about that with your counsel, with your attorney, I can set a plea and sentencing.
Okay, perfect.
A couple, maybe a month down the road.
That work for you so that you can get your AODA set up? Sounds good for the defense, Your Honor.
Here's the math reality. The court is laying out a financial buy-in path, roughly $300 per pay for the monitor plus $287 for the AODA assessment, landing around $600. In exchange, the judge is talking about 12 days on monitor instead of 15 days in jail, and the defendant is worried about work and explaining absences. Viewers, should the justice system offer alternatives that cost money, or should options be equal regardless of your wallet?
You want to get it,
Super sorry.
if you want to get it done sooner, I can fit you in. Because to fit you in nicely on my calendar, it would be probably the first or second week of April. Otherwise, if you think you can get the money sooner to prepay for the bracelet, as well as to pay for your AODA, which is $287, I think, I could get you in sooner. What are your thoughts?
Well, I guess my first question is how many days would I be looking at on something like that? 'Cause if I don't have to miss work or explain myself through employment, that would be ideal.
It would be 12 days on the monitor if I grant you house arrest with Huber, and you understand what house arrest is. That is $300 to prepay for the monitor. That includes the good time that you would get. And then the $287 for your AODA assessment. So we're looking at about $600. When do you think you can have $600?
I mean, if I,
Or quite honestly,
it's a big-
here's another thing. I just keep talking and because everything keeps, all these options keep coming in. We could do as plea.
Mhm.
I can stay on reporting for jail and or getting the monitor. I have 60 days. I never go the whole length of 60 days because something can happen. I could stay it for 30.
That works. for you?
yeah,
Yeah.
yep.
That would work for us, Your Honor. Appreciate it.
What about March 6th at 9:15? Could you do that?
Could you do that one? Could you be here? at
The
9:15?
Friday?
Yep.
That works for the defense, Your Honor.
All right, March 6th, 9:45, not 9:15. I apologize, 9:45.
9:45 work.
Yep.
Works for us, Your Honor.
All right, we'll see you then.
Thank you.
Thank you. We are adjourned.
This is the red flag but legal moment. The defendant is choosing to represent herself while in custody by video. The judge is doing the careful checklist, making sure she understands rights, the benefits of counsel, and the disadvantages of going solo. That's not just formality, it protects the plea from being attacked later. But viewers, would you ever plead guilty without a lawyer, even for costs only, just to end it?
Thank you.
There we go.
There you go. All right. So you're here without an attorney, but appearing by video conferencing in custody in Polk County Jail. At the last hearing, we went over the options of if you are able to get your license, but it's been a very long time. This is in November 2024. And so the court did say either we're setting it for trial or you can accept the offer from the state. And I believe it was pleading to count 1, operating while revoked for costs only.
Okay,
And that is correct.
okay, I will, can I just say I accept that then?
Yes, and we can take
Okay.
care of that today if you wish to do so.
Okay, we can do that.
Okay, and Ms. Julene, do you understand that you have the right to an attorney?
I do.
And so that means that you would have the right to have that attorney be there to help you through the process, to look at the evidence, to discuss with you any legal defenses you have or a lack of defenses you may have, all of those things. So do you understand that?
I do understand.
And you
I'm
wish
sorry.
to represent yourself?
I do.
And do you understand that having an attorney could give you certain advantages, like the things that I went over with you?
I do.
And do you understand that not having an attorney, you suffer certain disadvantages of the opposite of those advantages that I went over with you?
I do.
So how old are you?
45.
Can you read, write, and do you understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Have you been deemed mentally incompetent or suffer from a mental disability?
No.
You understand that you would have certain rights in addition to the right to have an attorney. You would have the right to have a trial. You'd have the right to have either yourself or an attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights?
I do understand, and I don't want to waste anybody's time.
Okay.
I'm driving to work.
Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
I do.
Do you understand the state would have to prove on or around November 2nd, 2024 in Burnett County, Wisconsin, while a person whose operating privileges have been revoked pursuant to Wisconsin laws, you did operate a motor vehicle on a highway or roadway during such revocation, and that revocation resulted in an OWI or similar offense?
Yes,
You understand that the maximum possible penalty could be a fine of not more than $2,500 or imprisonment of not more than 1 year in the county jail or both.
yes,
You also understand that there is an agreement reached between the state and yourself in which sentence. Do you understand that?
the screen just froze up, so I didn't hear what you said, the last part.
That the agreement is a cost only and there wouldn't be a recommendation for jail. Do you understand that?
I do.
Do you understand that I'm not bound to follow that? Meaning if I find some kind of issue with the case, I could sentence you to the maximum possible penalty or anything other than just costs?
I do.
Do you still wish to proceed and enter a guilty plea?
I do.
And you are entering a plea by video conferencing. Do you understand you have the right to be here in person?
I do.
And are you waiving that right to have the matter resolved here today?
Yes, please.
Now, do you understand that charge of operating while revoked?
I do.
Are you admitting here today that you in fact did operate a motor vehicle on a highway or a roadway of Wisconsin and this county while having your license revoked?
I do.
So you're pleading guilty because you are guilty?
Yes.
Do you have any questions for the court or for the state before I proceed?
This is huge and easy to miss if you blink. The judge is balancing accountability with realism. She's acknowledging the defendant has other financial obligations, so she waives court costs and only imposes the mandatory DNA surcharge of $200. That's not nothing. It's still a consequence, but it's a court saying, I want compliance, not collapse. Audience question, should judges do more of this, reducing fees to increase actual payment success?
For you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
I do.
and voluntarily?
Yes.
All right, then as to count one, operating a motor vehicle while revoked, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the charge. The other count will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
I think pursuing the conviction instead of getting the license back makes sense in this one because the defendant has a pending OWI in Barron County. So if she got her license back, she just lose it again and have to do the driver safety plan and all that all over again. And second, I think that a fine's appropriate in this case because this is not an OAR that resulted in an accident or a crash or injury. It did not even involve bad driving. It was a stop for expired registration. Thank you.
All right. Ms. Julene, anything you want to tell the court or argue to me?
I just want to say sorry that it's gone on so long. I really did plan on having this taken care of, but I'm just glad to have it done now.
Well, I'm glad you're resolving it, and I know that it's going to be some time. I forget why exactly you're in custody in Polk County, but you're taking care of it. You're being accountable. You're accepting the responsibility. So based upon that, I do find that costs are appropriate. And what I'm going to do is I know that you have other fines and fees that you need to pay and to get that assessment and to take care of all of that. So that's going to cost you more. So I am going to waive the court costs in this matter and only assess the mandatory DNA surcharge of $200. Okay?
All right. Thank you.
No problem. Yes. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm ordering you to provide your DNA. Polk County can probably take it. You have the
Okay.
right to request it be expunged from the system through a written letter to the Department of Justice. You're going to need to pay back your fines and fees. When are you released from custody?
I should find out hopefully within next week. I actually beat my revocation, so I'm just waiting to find out if they're appealing it, so.
Well, okay, that's good news for you. So what I'm going to do is I'm going to say that you can wait until March. That means anytime from March 1st until the end, the last day in March, to start your payments. And what I'm going to do is order $50 per month, okay? $50
Sounds good.
per month. If you're still in custody, write me a letter and let me know that, because otherwise I will issue a warrant and you could sit up to 6 months in jail on top of entering a civil judgment, all right?
All right.
Now, when you are released from custody, are you still at 407 Polk Avenue North?
No,
Now we've shifted into a classic plea condition standoff. Restitution first, plea second. The lawyer is basically saying, I can't finalize this because the deal requires prepayment, and it's not done. That's why the plea questionnaire isn't ready, because the agreement hinges on money being in the system. And you can feel the court's patience thinning because the dates go back months. Viewers, should plea deals ever depend on paying first, or does that create two different justice systems?
an actual address at the moment, other than here.
Okay, so would general delivery in Frederick be something where you can go to check your mail at the post office?
I do have a post office box.
Oh, what is that?
It's PO Box 53, Frederick.
Okay, excellent. So we will change your address to PO Box 53 in Frederick. Now, when you're out of custody, do you have either of these two telephones that end in 1230 or 1489?
No, I do not. I'm gonna have to get a different phone.
Okay, once you get a phone number, please call the Burnett County clerks so that we can update that, all right?
I will do that.
All right, sounds good.
Thank
Anything
you.
further?
I'm good.
Okay, thank you. Then
Have a good
we
afternoon.
are, what?
Have a good afternoon.
You two, we're
Thank
adjourned.
you.
All right, Miss Ekstrom and Mr. Gramstrup. We will go on the record in the matters 24 CM 182, 24 CM 224, 24 TR 864, State of Wisconsin versus Jatisha Ekstrom. The state appears through District Attorney Kevin Schmidt in person. Ms. Ekstrom appears in person. Mr. Gramstrup appears by video conferencing with approval of the court. We are set for a plea and sentencing. Mr. Gramstrup, is this matter proceeding as such?
It is not able to, Your Honor. I've had some communication issues with Ms. Ekstrom. She did ultimately email me last night. The court may recall that this offer involves prepayment of restitution. In her email, she indicated that she was hoping to pay some money today towards that. I'd have to defer to her to if she did and how much, but I don't think that I don't think it's been paid in full. And as a result, I've not been able to go through a plea questionnaire and prepare her for a plea and sentencing.
Okay. It doesn't look like it is paid in full. So, Mr. Gramstrup, I know that you're kind of taking a little break from jury trials. What I'm going to do is I am setting this for a jury trial and a final pretrial, but I will set it for another potential plea and sentencing if I can get assurance that Ms. Ekstrom is going to be able to make that restitution in sometime soon, because this is getting very old. This is from August 2024 and November 2024. So Ms. Ekstrom, do you have the ability in the near future to pay off the remainder? Because I know you paid $330 today.
Yeah, so my mom got sick. I quit my job, my mom got sick, and I just got a new job that actually is paying me better. So I honestly, like, so what are we up to, like 780, something like that? there's a couple few $100s left. I know I can have that paid like literally in the next month, like no questions asked.
Okay, so, all right, so here's,
The remain, I don't mean, I'm sorry to interrupt you,
Okay.
but like the remainder, I should be able to have it like within the next month, if not less.
Mr. Schmidt.
I think she's only like 240-ish bucks short, if I mathed it right.
I am not quite certain, but we have 330 from today. We have 250 from a different day. We had 60 from another day. So that's 640 and it was 1,025. So $385.
Thought we were closer to 800 or.
That's not what I have.
Cause I know I sent a money order for 60, well, maybe it was like 140. There was a $60 payment and then there's the 250 for high bail when I got out of jail. And then I just paid 330.
Well, the clerk, Olivia, can double check, but I'm only seeing 3 payments. And a total owed restitution of $1,025.15. That doesn't even include court costs and fees. But I believe that the recommendation was for 1 year of probation.
Yeah, it adds up to 780 if I'm looking at CCAP on 24 CM 224.
Well, the clerk will have all of the records. I only have,
780.
there is 780. When were the payments? I only have documentation of the 250, the $60 and that 330 today.
There's 140 on July 7th or November 17th.
November 17th.
Yeah, you wouldn't get them yet because it takes a while for you. So
Okay.
yeah, we have 60, 140 and 330 and then the 250 bond.
Okay. All right. So
Seems to me she's pretty close. I don't know if she's got her tax refund yet or not.
I haven't even filed my taxes yet. But like I said, the job I'm working at, I'm making better money than I was before. So like I said, like it'll take me less than a month to get the rest of it. Like,
all right, if you're giving me assurances that it will,
yeah, absolutely, yes.
and if you can pay more, I'd pay it down some of your court
Yeah.
costs and fees.
Yeah.
And it's plead to 1 misdemeanor.
Yes.
So here's the deal too.
Yeah.
This is a lot of money for you to save. I know your financial situation. I know your
Right.
past life situation. If you can come up with an additional $200, I'll waive the remaining fines and fees.
Right on. Okay.
Okay, so if you can do
Absolutely.
that by your plea and sentencing,
Yeah.
I'll waive the rest. Okay. Because I know what it's taken you to get this money.
Yeah, it's been I've had so many things come up and it's redundant and ridiculous and it needs to be taken care of.
I'm sorry to hear that.
Yeah, it's okay.
I can do March 23rd at 1:30 if that works, if Mr. Gramstrup can appear by video.
Okay.
Does that work,
Works
Mr.
for me.
Gramstrup?
It
Okay.
does.
All right, and Mr. Gramstrup, again, with the plea questionnaire, I'm not so concerned about you getting her signature. She can sign it in court. Just make sure you go over it. Or if you can't go over it, I understand that too. This is a misdemeanor. I can go over all of that with her myself.
I should be able to. I mean, there's been an issue with your phone, Jatisha. So what's the situation of that? Are you able to?
So my phone, I don't have phone service. I connect through Wi-Fi and like it's like my kids' phone bills are paid, my phone bill is paid. So if they're home or not in class, then I connect off their Wi-Fi, or at work, I connect through that Wi-Fi. So it's just a matter of like, if we could like set up a time, if you're like, hey, I'm gonna call you at this time, I can absolutely guarantee that I can be like available at that time.
Would you
Okay.
like
I'll send-
to set something up now?
What I'll do is I'll send you a new plea questionnaire, and in that
Okay.
letter, I'll set up a date and time to talk to you to review it.
Okay, sounds good to me.
Excellent. Thank you guys so much. Okay, so I won't set a trial right now because I'm trusting that you're gonna do it.
Thank you.
You sound like you're working hard.
Life is finally starting to like get to where it needs to be to just keep it going.
I
And
am-
it's been a while, it's taken a long time to get here, so I do appreciate it, thank you.
I'm very glad to hear that because there was a time where you were
Like,
pretty low.
yeah, I know, yeah, I'm glad to be past that.
I'm glad too. It's better
Yeah.
for you. It's better for your kids.
Oh my gosh, yes. Yep.
So I'm very happy to hear that.
Thank you.
All right. So then that's the plan. I've set the date and time, March 23rd. We'll see you then. You can come get your notice. Thank you, Mr. Gramstrup.
Thank you, guys.
Thank you. Have a good day.
We are adjourned. Thank you, Ms. Molsom. I have meetings the rest of the day, so there's nothing else I need you for, but I appreciate you filling in today. Good morning, Ms. Molsom. I apologize for the delay. I had an impromptu meeting that I wasn't expecting.
Okay, good morning.
Good morning. And our first case isn't here anyway.
Oh,
Unless Mr. Vila, if you can tell me, did he do the classes? Did he get confirmation?
I've seen nothing filed by Mr. Dave Hatch regarding confirmation or payment for the course. So as far as I'm concerned, it hasn't been completed.
And we haven't gotten the payments, nothing. So, all righty. We will go on the record in the matter 25 CM 179, State of Wisconsin versus Christian Madison. The state appears through Assistant District Attorney Jose Vila in person. Mr. Madison fails to appear. This matter was set for 9 o'clock. It is now 9:09 and no appearance by Mr. Madison. He was given the ability to appear by video conferencing or to be here in person. He fails to appear by either means. The court does have video conferencing up and no one is waiting to come into the courtroom. The weather is great and it's supposed to be, I believe, a high of 50 or 51 today. So there is no weather issues with driving. He resides in Spooner, so it's not a long drive, but again, he was given the ability to appear by a video conferencing if he so desired. He fails to appear. What is the state requesting?
I would ask for a warrant, Your Honor.
What you've just watched is a snapshot of how courtrooms juggle real-life chaos with legal structure. One defendant navigating treatment versus jail time and the real cost of monitoring. Another resolving an operating while revoked case through a plea with major rights advisements and a cost-focused outcome. And another facing delay because restitution wasn't fully paid yet, pushing the court toward trial settings unless progress happens. Add in the no-shows triggering warrants, and you see the court's core message: show up, comply, and take accountability or consequences escalate fast. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
The court will issue a warrant, $500 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. We are adjourned. All right, thank you. I guess we have 5 minutes and then we will move on to our next one. Thank you, Ms. Molsom.
okay.
We will go on the record in the matters 25 CF 146, State of Wisconsin versus Riley Jones. The state appears through Assistant District Attorney Jose Vila in person. I do not have Riley Jones, nor do I have Michelle Erdman. Michelle Erdman was present and appeared by video conferencing Zoom. When the court inquired or actually stated to Ms. Erdman that I did not have Riley Jones, all of a sudden she was off of Zoom, and that was at 9:16 as the matter was scheduled for 9:15. It is now 9:21 and no appearance by Mr. Jones, nor any appearance by Ms. Erdman. Driving conditions are great. Weather is supposed to be 51 degrees today. Again, no one's appearing by video conferencing, even though Mr. Jones did not have authority to do so. Mr. Vila, what is the state requesting?
I would ask for a warrant, Your Honor.
All right. The court is going to issue a warrant. $500 additional cash. Well, actually, yeah, $500 additional cash to be posted. The court is going to forfeit the cash previously posted pursuant to 969.13 of the Wisconsin statutes. I am going to stay the forfeiting of the cash and the order to be entered. I'm going to stay it until Wednesday to hear if Mr. Jones and/or Ms. Erdman was confused about today's hearing, since the state did dismiss 25 CF 179 and the court signed the order today. I don't know how there is any confusion of appearing today for the court's hearings, because we were set for a preliminary hearing on the matter that was dismissed. We were set for a status conference on 25 CF 146, and we were set for a bond modification hearing for 25 CF 146. Therefore, both should have known to appear here today, and neither appear. All right, we are adjourned. Thank you. All right, Ms. Molsom, we are off until 9:45.
Okay,
The
sounds good.
9:30 that's on there is dismissed, or it's been dismissed.
Okay.
All right, thank you.
Okay,
All right, can you hear me?
yes,
Ms. Matrius, I see that you're in custody, and from the jail roster, it says probation violation. I don't know what it is beyond that, but I'm gonna guess, since you're in custody, you never had an opportunity to discuss the case with Mr. Schmidt?
no, I did not, Your Honor.
All right, so we'll go on the record and we'll see what an offer could be, and we'll go from there, okay?
Okay,
We will go on the record in the matter 25 CM 238, State of Wisconsin versus Claudette Matrius. The state appears through District Attorney Kevin Schmidt in person. Ms. Matrius appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a status conference. The matter was set very quickly. She was here last week for a status conference, but it was on Mr. Vila's week, and this is a Mr. Schmidt case. Therefore, we reset it for this date and time so that she can have an opportunity to speak with the district attorney about an offer and go from there. However, in the meantime, she was placed in custody for a probation violation and has not had the ability to speak with the district attorney. He is now back from his conference. She is here without an attorney. She requested to represent herself at the last hearing. She would still have the ability, if she would like, to have a court-appointed attorney once she does put down a $300 deposit. But right now, she wishes to represent herself. Mr. Schmidt, is there an offer that can be presented to Ms. Matrius?
The offer I'd make right now would be pleading the child neglect in 25 CM 238 for 1 year probation. 1 year probation with a state imposed sentence of 60 days.
All right, so Ms. Matrius, do you understand what the offer is?
yes,
Okay, to plead to count 2, counts 1 and 3 would be dismissed and read in, and the state would be asking for 1 year of probation with 60 days of jail that would be imposed but stayed, nothing that you would sit immediately. Okay, so do you understand that offer?
I think I do, Your Honor. If I mess up on that 1 year, I have to do the 60 days.
Correct. That is essentially what it is. So go on probation for a year. That would be tacked on to, or actually it would run concurrently with the probation you're currently on, unless you're being revoked.
No,
And then it would be a sentence of 60 days imposed but stayed. So 60 days kind of held over your head so that you can do what you need to do on probation. If you're revoked from probation, then that 60 days would take effect. Okay, so do you understand?
yes,
Are you being revoked?
no.
Okay, so I only get to see that it's a probation violation. I don't get to see what it was. I don't get to see if they have you on a sanction, if they have you on a revocation. So do you have a specific sanction? Are you going to be sitting for a little bit?
No, Your Honor, I'm supposed to be out today. They were going to try to try to get me into a treatment center in Balsam Lake, but I don't think that's gonna happen, so she's gonna release me.
Okay. All right. So you understand the offer. Is that an offer you wish to consider? You don't have to tell me that you want to take it now, but is it just something you want to think about and consider?
I'll think about it, yeah.
Are you okay, Miss Matrius? You don't seem
Yeah.
like yourself. I know you're in custody, but you
Yeah,
don't
I'm
seem
okay.
like yourself.
I'm okay.
Okay. All right. So what I can do is set this for a couple weeks down the road. And then I can get an update on if you wish to accept it. If you do, then I can take your plea that day and get it resolved. If you wish to not accept it and to speak with the district attorney more, or you wish to then get a court-appointed attorney at that time, then you can just let me know, okay? So those are your options.
Okay.
I'm going to schedule you for March 9th at 3 o'clock. March 9th at 3 o'clock, okay?
Okay.
And so that's a Monday. So what you're going to need to do is, if you're not in treatment, you're going to need to come to the court, and then we will see what's going to happen with the case. If you are in treatment in an inpatient treatment facility, you can appear by video conferencing, okay?
Okay.
All right. So just think about the offer. You can talk to family, friends. You can talk to your probation agent, although they cannot give you any legal advice. And then just let me know on March 9th what it is you want to do, okay?
Okay.
All right. Thank you.
Thank you.
We are adjourned. All right. Ms. Molsom, we are now going to be off until 10. We will go on the record in the matter 25 CF 153, State of Wisconsin versus Larry Kruger. The state appears through District Attorney Kevin Schmidt in person. We have Christopher Gramstrup, defense counsel by video conferencing with approval of the court. Mr. Kruger is in person. We're set for a status conference. Mr. Gramstrup, can you please update the court?
I can, Your Honor. I believe the matter is resolved. I think we could set it for a plea and sentencing on a joint recommendation. My understanding is he would be entering a plea of guilty to possession of meth. There would be a joint recommendation of 18 months probation. Other count would be dismissed and read in.
All right. I could do it as early as this Friday morning.
I don't think I'd be able to have a plea questionnaire and be prepared by Friday.
Okay. I could do, ooh, maybe I couldn't. Wait. Oh, okay, you're confusing me, Mr. Schmidt, with you being here, and it's your case? All right, I could do it as early as February 24th at 2:15.
I think I can do that. If I could ask Mr. Kruger, do you have the ability, if I email you a plea questionnaire, to scan it and print it and review it with me and email it back so we don't have to deal with the US mail?
I don't have capability on my phone right now.
And Mr. Gramstrup, here's the deal. You're a great attorney. You always do what you need to do. I can count on that. I am fine if you just go over the plea questionnaire, or you make sure that he has a copy, or I can give him a hard copy without you filling it out, as long as you go over all that you've filled out. He comes to court, he signs it in court, then we have the hearing.
We can do that. That'll work.
All right. So does that work for you, Mr. Kruger? Okay, so we'll see you February 24th at 2:15. Mr. Kruger, do you have the ability to either get a text copy or an email copy of the document?
Not right now until I get paid again, and that's not until the fourth Wednesday of each month.
Okay, so you don't have a phone right now?
I have no internet on my phone. That's the only thing I got.
Are you able to do Wi-Fi phone?
No.
Okay. I'm sure we have a plea questionnaire waiver of rights document. There's one out there by the clerk, right, Olivia?
We might have one.
All right, so I'll just make sure that he stops at the clerk's office, gets a copy of a plea questionnaire, and then so he'll have it with you, so then you can go over it with him on the phone, unless you're going to meet in person, okay?
Mr. Kruger, your phone is working. We can talk by phone though, right?
Yeah, the phone works.
Okay.
That's all I got.
Perfect.
That's fine.
Okay,
Okay.
perfect.
Mr. Kruger, so we'll see you on February 24th, 2:15. When you're done here today, go right out to the clerk's office and ask for a plea questionnaire, okay? Just an empty document, plain document, okay?
And give him his notice.
Or never mind, Olivia is on the ball and she'll just print it for you, okay? We're good to go. Thank you.
Mr. Kruger, make sure you're available to speak by phone tomorrow morning.
Okay.
All right,
All right,
thank you.
we're adjourned. And Mr. Gramstrup, I have somebody in Polk County Jail right now. I'm just gonna quick do her hearing and
Sure.
then
Nope.
move on to Miss Ekstrom.
No problem.